Hi, everyone. Thank you for coming to the FedSoc event today for the debate. We're really looking forward to the topic and to both of our speakers. We're very thankful that they took time out of their busy schedules to come here and to talk with us. Professor Edwards is here, but he still has a very busy schedule, so we appreciate him a lot. Today's debate is about the constitutionality of DEI in higher education and whether or not it's constitutional. So I will go ahead and turn it over to Professor Rogers to introduce our two speakers and to preview the debates. So thank you all. And if you're interested in Federalist Society, please come talk to me afterwards, and we'll get you signed up for the group, for the club. Thank you.
Well, thank you all for coming. Great turnout, great crowd. I know I joked last time about the capitalist feeding you the good pizza, but here we have Oliverios. I'm not sure I've ever seen Oliverios catered in my 7 years at the law school. So by all means, enjoy yourself a good lunch and hear some interesting ideas. It is an important topic. Some of you were in the room in the spring when I taught employment discrimination, and the law in January on DEI when the course started was very different in May when the course ended. So there is a lot for all of us as lawyers to learn about and be informed about. We have two speakers today. The first one, our guest, is Alison Somin, who is a senior legal fellow at the DC office of the Pacific Legal Foundation. She previously worked for a number of years at the United States Commission on Civil Rights. In addition, we have Professor Edwards, who I understand is teaching civil rights this semester. Some of you are nodding. All right, you're at his class. Good, good. And then in the spring, we'll teach constitutional law as well. He is an impressive scholar. Articles coming out, Boston College Law Review, Harvard Law and Policy, online components of the Georgetown, Florida, lots of publications. Before joining us here at the law school, he was a litigator at the ACLU of Florida, where I understand he worked on some of these DEI issues in higher education. My understanding of the speakers from Ms. Somin, we'll hear about some of the historical background to the key Supreme Court case in Students for Fair Admission, and she will also give her views on where the law should go. Professor Edwards will talk about his views of what DEI is and why it is valuable. He will then talk about some of the implications of Students for Fair Admission and also some of the First Amendment issues regarding DEI in higher education. In particular, you may see some clash between the speakers on to the extent to which after Students for Fair Admission can race-neutral means be used to promote racial diversity and integration. So many important legal issues, and I look forward to the presentation.
Thank you so much for that kind introduction. It's great to be here. Before I get into the meat of this presentation, how's the audio? All good? Excellent. Today, I want to tell you about, 1, the background leading up to the Students for Fair Admissions versus Harvard decisions. 2, some basics of the case, including its facts and holding. And 3, the ramifications of the case for DEI on campus. Spoiler alert, I think the case was rightly decided and will have largely beneficial effects on law and public policy. Let's start at the beginning, jumping back a century and a half. In the wake of the Civil War, 3 major amendments were added to the Constitution to outlaw slavery and to realize the promise of the prohibition on slavery and to fully integrate the newly freed slaves into American life. One of these, the 14th, contains a clause requiring, quote, equal protection under the laws, close quote. Basically, everyone at the time understood that this clause was primarily about helping the newly freed slaves integrate into society. At the same time, Congress deliberately went with broad text. It rejected some narrower versions and chose an amendment that was universal in its language and its scope. Very early in the amendment's history came Equal versus Hopkins, an 1886 case involving a challenge to a San Francisco ordinance that banned certain kinds of commercial laundries housed in wooden buildings. These laundries were almost exclusively owned by Chinese Americans, and basically everybody involved understood this ordinance to be targeted at a particular racial group. Despite Chinese Americans not being newly freed slaves, the court held that the amendment applied to this kind of discrimination and outlawed it, another indication the 14th Amendment was, from its early history, meant to be universal. Unfortunately, a nadir in the enforcement of the 14th Amendment came a few years later with the infamous Plessy decision in 1896. Then, a long series of cases slowly revitalized its meaning and its promise. One that's interesting that I want to bring your attention because of its implications for universal readings of the 14th Amendment is Buchanan versus Worley from 1917. This was a case challenging a racial segregation ordinance from Kentucky. What's noteworthy about it is that it involved a white plaintiff suing a black defendant. Buchanan, who was black, bought a parcel of land in a neighborhood limited to white residents under the ordinance from Mr. Worley, who was white. If Buchanan couldn't lawfully make this purchase under the residential segregation ordinance, then under relevant contract doctrine, the deal was off and he didn't have to pay Worley. Worley indeed demanded payment and Buchanan refused, citing the ordinance as a defense, and Worley then sued Buchanan. If this all sounds a little bit ginned up, that's because it probably was. The case is generally understood to have been set up this way because the local civil rights groups thought that this particular posture would be more sympathetic to judges. It's an interesting case with regard to colorblind application of the 14th Amendment because, although it was clear to everyone involved that the broad social purpose of the lawsuit was to strike at segregation, the person bringing the claim was actually white. As the Supreme Court said, the objection is made that this writ of error should be dismissed because of the alleged denial of constitutional rights involves only the rights of colored persons and the plaintiff in error is a white person. But the court nevertheless struck down the ordinance because, quote, this interdiction is based wholly upon color, simply that and nothing more. A peak case for our purposes came in 1954 with Brown versus Board of Education, a landmark case that may be familiar to many of you from even before you started law school. It overturned separate but equal facilities in public education as inherently unequal. The decade immediately following Brown also saw the enactment of some major civil rights statutes intended to uphold the promise of these decisions. For us today, the most important is probably Title VI of the Civil Rights Act of 1964, which prohibited discrimination based on race, color, or national origin by recipients of federal funding. Although its drafters were mainly concerned with dismantling Jim Crow, Title VI's text is race neutral. Its drafters knew that racially preferential programs with purportedly remedial purposes existed. They could have drafted text that authorized them, but they didn't, perhaps because they realized that these programs weren't popular and would have doomed their ability to get more moderate supporters of the civil rights movement to sign on. After Brown, efforts to correct the injustices of segregation and Jim Crow shifted somewhat away from colorblind efforts and toward programs that gave preference to Black Americans in certain contexts, including education, which is the focus of today's date. The first major post-civil rights era case involving race preferential admissions went to the Supreme Court in 1977. That's the Regents of the University of California versus Bakke. Alan Bakke, a white plaintiff, challenged the University of California's system of race preferences and admissions. Unlike some later affirmative action programs, there was a very specific set-aside at stake in this case. A certain number of seats were reserved for Black students. This program was first overturned by the California State Supreme Court. Judge Stanley Mosk, a quite liberal judge known for his advocacy for civil rights, wrote for the majority, striking it down. To uphold the argument for race preferential admissions would call for the sacrifice of principle for the sake of a dubious expediency and would represent a retreat in the struggle to assure that each man and woman shall be judged on the basis of individual merit alone, a struggle which has only lately achieved success in removing legal barriers to racial equality. Powerful as I find that argument, the Supreme Court went the other way in a fractured 4-1-4 opinion. Justice Lewis Powell was the swing justice whose vote was necessary to get to a judgment. He wrote a concurring opinion in which he struck down the University of California system, mainly because it was so explicit about its racial aims. He contrasted it with something similar to Harvard University's system, which didn't explicitly set aside seats based on race, but which looked at, or at least claimed to look at, applicants holistically with regard to many non-academic factors other than race. Because of the fractured nature of the Bakke opinion, uncertainty about the state of the law persisted. This led some years later, in 2003, to the doubleheader of two cases going up to the Supreme Court involving the University of Michigan, one against the law school, Grutter, and one against the undergrad school, Gratz, in 2003. In Gratz, the system of admissions at Michigan undergrad, which used a very explicit point system based on race, was struck down. By contrast, the system at the law school, the one challenged in the case called Grutter, upheld race preferences. Grutter took a somewhat surprising path to get to its result, and I think that contributes in part to why it was overturned so readily some 20 years later. I've done a decent number of Federalist Society talks, debates, and other events on this topic, and almost always, if there's a second speaker, or if I get a challenge from a student in the audience, he or she will try to defend preferences mainly on the basis that they're intended to remedy past discrimination, what scholars sometimes call compensatory justice arguments. Interestingly, the two justices who were in dissent in the Students for Fair Admissions case, which we'll get to soon, they also spend almost all their time and words on these historical compensatory justice arguments. This is kind of strange because these justices are arguing for upholding a version of Grutter that didn't exist. The majority opinion in that case was written by Justice O'Connor. She instead grounded its logic. Universities could use race preferences at admissions when such preferences are narrowly tailored to further a compelling interest in student body diversity. She wrote about the special pedagogical interest that universities have in obtaining a diverse student body to enhance learning and prepare students for leadership in broader society. You'll note that there's nothing in here about slavery, nothing about history, nothing that sounds like a compensatory justice argument. Why is that? Maybe because Justice O'Connor thought she was boxed in by the court's earlier decision in Bakke. Maybe because she thought this sounded more forward-looking and optimistic than something that emphasized the country's past sins. Maybe partly because she was persuaded by an amicus brief by the military academies that defended the need for race preferential admissions there on these particular and specific grounds. There are some obvious problems with this argument. One, it's not obviously true that diversity is necessary for good teaching. This is an empirical question. Researchers have attempted to look at whether students in racially diverse classrooms learn more than classrooms that are less so, and the actual data they've come up with is all over the place. Diversity is probably most pedagogically useful in humanities and social sciences, a field like government or sociology. It's arguably least so in something like mathematics or physics. Yet many universities actually gave their most generous admissions preferences in mathematics and sciences. Were preferences benefiting the learning of the students they were supposed to help? Can walk through the data on this later in Q&A, but there's a lot of studies indicating the answer is no. Can the pedagogical argument really hold if the students getting preferences themselves aren't benefiting? Probably not. Finally, did universities really believe in diversity as a broad goal, or were they just largely reciting the word diversity to get them the racial numbers they wanted for other reasons? There's lots of evidence for the latter. Most selective universities don't really give preferences equivalent to the ones they give for race for other kinds of diversity or underrepresented views. They don't go out of their way, for example, to recruit political conservatives or evangelical Christians. The way the typical selective admissions program is designed suggests that universities care more about racial numbers for their own sake rather than about creating a diverse learning environment. The cert petition in Students for Fair Admissions contains the line, "Nobody believes in Grutter because Grutter is not worth believing in." I think that is an accurate and pithy summary of the problems with that case. Fast forward some 20 years to the Students for Fair Admissions case. This was two joined lawsuits brought by a group of students and parents against two prominent universities. One against Harvard University, a prominent private school, one against the University of North Carolina, a very prominent public school. Both challenged the use of race preferences in admissions. They went up to the Supreme Court together as a matched pair. In his majority opinion, Chief Justice Roberts noted that the baseline rule of our Constitution, as I discussed earlier in my remarks, and of Title VI of the Civil Rights Act of 1964, is that race discrimination is unlawful, even race discrimination that supposedly has benign or remedial intent. Grutter was supposed to create a limited exception in student body diversity cases, but in practice, it wasn't really generally interpreted as limited at all. The supposed exception was swallowing the whole, and most schools were just using race broadly. The Students for Fair Admissions decision overturned Grutter in all but name. As the chief wrote, eliminating racial discrimination means eliminating all of it. This decision was only about admissions, and so questions persist about the future of forms of diversity, equity, and inclusion other than admissions. With regard to trainings, programs that separate students by race, I think it's clear from Students for Fair Admissions, and even just in the plain text of the statute, as read before Students for Fair Admissions, that these are unlawful. It was never really clear that Grutter's special exception for diversity applied outside of admissions, and I think that's even more clear now. And this is good. As Justice Thomas has written, placing us on racial registers, allocating benefits and burdens by race, demeans us all. Thank you for hearing me out today. I look forward to your responses and your questions.
Good job.
I'm going to set a timer because those of you who are in my class, you know that I'm a bit long-winded. So I think Allison did a great job of setting the table here on the law and the stakes. So I'm going to start first by talking a little bit about why DEI is important and what it is. So what is DEI in higher education? Affirmative action is one aspect of DEI, and I think for the reasons that Allison has laid out, it is one that is no longer going to exist moving forward. And I'll get into that. But there are other aspects to it. There are diversity trainings and compliance with civil rights laws. We also have, and again, I'm going to define DEI pretty broadly, at least consistent with how I think the federal administration is defining it. So certainly there are debates as to what exactly DEI is, and I don't intend to provide the definitive account, just what I understand our federal government to see it as. But it also includes research on diversity-related issues, on race, on gender, sexual orientation, classroom instruction on diverse topics, and affinity groups, affinity-based programs, related things of that nature, even student organizations, events, debates. And so it's a very, very broad issue. And I think a lot of aspects of DEI is important. I mean, even today, we have what could be argued as a DEI event, where we have intellectually diverse speakers debating over an issue in higher education. So why is that important? Well, first and foremost, I think that diversity benefits us all. You know, when we meet with people, when we speak with people, when we learn with people, or learn from people and learn with people who have different perspectives from our own, who have a different background from our own, who have had different experiences from our own, it enriches our perspectives, it makes us more effective. I was on many diverse legal teams, and what I realized is that people who had a different upbringing than myself, who came from different backgrounds, they were able to see a lot of things that I couldn't. And at first, I took that as kind of a negative for myself. Like, why am I not seeing these things? And then what I realized is we're a team. And the fact that they see things that I don't, and I see things that they don't, it makes us a stronger team. And so I think diversity is very important. I think equity, at least as I see it, equality of opportunity, not equality of outcome, that's important. Giving people an equal shot at succeeding, eliminating barriers and obstacles that would stand in their way, that's important. And inclusion, being kind to people, making them feel respected, regardless of who they are, regardless of their background, regardless of their socioeconomic status. We should try to make our law school a welcoming environment, regardless of your political views, your ideological views, where you came from, what race you are, what gender you are, your sexual orientation. So I think in those respects, DEI does a lot of very good things. Now, I'm not here to defend every single aspect of DEI. There are certainly opportunities and times where people go overboard and where they do things that I think are unwise or unhelpful. But that's true of almost anything. I mean, if you look at the people who framed our Constitution, they were not universally and uniformly good. They did some things that were pretty awful, including upholding slavery. And so there is no one thing that should define, whether something is good or bad. These things have nuances and layers. So with that said, I do think DEI is important. I think it is worth preserving, although we need to be mindful of its use, and we need to be mindful and respectful towards others. Now, what is the state of equal protection law? I agree with Allison that racial classifications, sorting people based off of their race, black people over here, white people over here, in admissions, in other university-sponsored programs, that's no longer sustainable after Students for Fair Admissions. There are some scholars who disagree, who think that Student for Fair Admissions left some room to do that. And in a very technical sense, Chief Justice Roberts maybe left a little bit of room for that if you could justify it under strict scrutiny. But I think the reality of the situation is there's just not going to be cases where they uphold it. Where there's a little wiggle room technically in the law, I don't see racial classifications surviving. Whether that's in admissions, whether that's in hiring, whether that's in scholarships, and whether that's in other sorts of programs. Now, where I do see diversity and similar issues continuing to survive is on the purpose side of things. So you have to be race neutral in how you're implementing things, whether that's university-sponsored graduations. You can no longer have a graduation that's only for black students or a graduation that's only for white students. But you can, as a university, use your, say, DEI program to enhance your applicant pool and to try to have a class that is more diverse through race-neutral means. An example is in Texas, they allow in the top 10% from, I think, every school district. And so if you are in that school district, regardless of your race, and you're in the top 10%, you're automatically admitted to public universities. And some people would argue that that enhances diversity, both in terms of geographical diversity, but also in terms of racial diversity, because some areas are more white, some areas are more black, and if there are areas that are underfunded that correspond to race, and unfortunately we often see that, then it may create obstacles to the same sort of achievement that would make it harder for students from that area to get the same GPA. Maybe they don't have the same access to community college courses. Maybe they don't have the same access to honors or AP courses. Maybe they don't have the same access to test prep. And so those sorts of things would make it more difficult. And in that sense, by having this top 10% policy throughout the state of Texas, regardless of the resources, it is race neutral, but it might result in enhanced diversity. And I think SFFA still leaves room for that as equal protection law when looking at racially discriminatory purpose. In Arlington Heights, it only looks for invidious purposes. And invidious means hostile to race, not trying to help a group, but trying to harm them. And I agree with that. I think that is the right approach in these sorts of cases. And why is that? Well, I don't think that we should treat attempts to integrate as the equivalent to attempts to segregate. I don't think we should treat public policy aimed at reducing disparities as the equivalent of public policy aimed at increasing racial disparities. And so, just to offer one example, and maybe in the research funding context, if there's a program that has the purpose of, it's race neutral, it can go to any scholar of any race, but the purpose of this program is to reduce racial disparity in maternal mortality outcomes or infant mortality outcomes, because what we're seeing is that black women have much higher rates of death in terms of maternal mortality following pregnancy, and babies born to black mothers are over twice as likely to die as infants as babies born to white mothers, trying to reduce that disparity, to bring them to a point where they're actually equal, trying to find the public policy solutions that will actually address these issues in race-neutral terms. I don't think that sort of thing should be unconstitutional. And certainly I'm not suggesting that Alison would say that they are. I will happily let Alison speak for herself. Before I wrap up on SFFA and equal protection, I will say that I do have my reservations about whether this decision is correct. I don't want to litigate this issue right now, as I think our debate is going to be very lively just on what we have presented so far. But I think both on living constitutionalist and originalist terms, there are reasons to question SFFA. But I certainly see the originalist arguments for why people think SFFA is correct, why they think racial classifications should be per se unconstitutional, and why this anti-classification theory of equal protection has persisted and even succeeded. But hearkening back to originalism, I am of the view that arguing that race-neutral laws that promote race-conscious purposes, arguing that that is unconstitutional under the Equal Protection Clause, I do think conflicts with the original understanding of the 14th Amendment. After all, the Civil Rights Act of 1866 and the 14th Amendment was passed specifically to make sure that the Civil Rights Act of 1866 was constitutional, in that it was phrased in terms of people having the equal right to make contracts, enforce contracts, and various other civil rights as white persons. And the rationale behind it is that black people at the time were being disfavored, both freedmen who had been freed from slavery and free blacks in the South, that they were being disfavored, that they were being discriminated against in the South, and that they needed this protection from this law to be given an equal shot in society. And so if we are to take the stance that a race-neutral law that seeks to accomplish racially conscious purposes is unconstitutional, that would call into question the constitutionality of the Civil Rights Act of 1866. It would call into question the constitutionality of other laws passed at the time by the same Congress that drafted and passed the 14th Amendment, including the Freedmen Bureau's acts. And so I think under an originalist view, and certainly a living constitutionalist view, race-neutral laws that promote racially conscious purposes, as long as those purposes are not invidious, as long as they're trying to help a group who is being disadvantaged, are not unconstitutional. With the few minutes that I have left, I'm going to try to briefly address the First Amendment. This is a much longer conversation. For those of you who are interested in this and did not attend the Constitution Day presentation, if it's available on YouTube, I highly recommend watching it, as we got very deep into these issues there. But in terms of the First Amendment, I think the clear distinction here is that expressive DEI policies in higher education are usually going to be constitutionally protected. They're not going to be constitutionally protected when they constitute government speech. That is when the government is speaking. Trying to explain the distinction there would take much longer than the 3 minutes I have. So I'm not going to do that because I think Alison and I are mostly aligned on this issue, if not totally aligned. But when the government comes in and says that in order for you to research this issue, you must come to our conclusions, that qualifies as viewpoint discrimination because they're choosing one side of the debate over the other, and that would be unconstitutional. It is similarly unconstitutional for the federal government to say you can't talk about diverse issues in your constitutional law class, Professor Edwards. As an instructor, I've been tasked with teaching constitutional law. If race is part of constitutional law, and it very much is, I have the academic freedom, the First Amendment protected right to discuss the various viewpoints there, as long as I am doing so in a way that is consistent with academic standards. Finally, student organizations like the Federalist Society who want to present and held debates on issues of DEI, on issues of race, they are also protected by the First Amendment. And you as students have audience rights, both at this debate and in the classroom. Now, those audience rights aren't always super robust, but in terms of the federal government being able to tell you what you can and can't learn, you have protections against that. So I think I will stop there. I will simply end with, I do think that there is still a lot of value in race-neutral laws that seek to accomplish racially conscious purposes. We as a society are not yet perfect, and I think we should continue to strive to be perfect. We may never reach that, but we should strive to eliminate racial disparities that exist to the best of our abilities. We should strive to address other disparities, whether it's unequal pay for women, whether it is discrimination against transgender people. I think we have a duty as a society to pass public policy to address these sorts of disparities, to address discrimination, both historically as it is impacting the present and in the present. And I think that there are protections for states that do so. I don't think the Equal Protection Clause prohibits it. And certainly, I have a right, a First Amendment right, to express these ideas, whether or not the government supports it. So, thank you.
Thank you. Just a few notes. I think that we agree that there are certain that diversity, equity, and inclusion is a broad term, and I'm not going to try to put much. I recognize sort of the limitations of spending a lot of time trying to define that term precisely. We agree that there's a lot of actually existing DEI training that doesn't offend the Constitution, that merely aims at race-neutral goals like bolstering equality of opportunity or bolstering kindness on campus, and I have no objection to that. My concern is that a lot of real-world DEI training does either explicitly classify by race, scholarships, events, trainings that are limited to persons only of one race, and those programs violate the Constitution at public institutions, and when at institutions that receive federal funding, violate Title VI of the 1964 Civil Rights Act. There are other forms of DEI that I think are unwise or unhelpful. I don't think it's helpful, as one popular DEI training says, to claim that worship of the written word is white supremacy culture. I think that persons of all races can love books and love writing, and that promoting stereotypes to the contrary is unhelpful and hurtful. That said, this sort of thing isn't obviously a legal violation unless it's paired with other use of stereotyping or harassment sufficient to qualify as a hostile environment in violation of Title VI. I think Professor Edwards and I largely agree that Students for Fair Admissions eliminates basically all use of race in higher education admissions. I can talk a little bit about military academies or essays during the question and answer period if people are interested, but I think that we agree on those. We agree on those nuances. Where we may disagree more is on the use of race to achieve, or rather on the use of race-neutral programs to achieve race purposes. This is something we've seen earlier in our nation's history. In the era of legal challenges to Jim Crow, Southern towns, Southern officials weren't stupid. They tried to find ways to evade lawsuits, challenging the use of grandfather clauses that kept Black voters from voting, and property qualifications for voting, and so on. These were measures that were race neutral on their face, but that everybody understood in practice to be discriminatory. The Yikwo case involving San Francisco and the Chinese laundries that I mentioned to you earlier during my case in chief, this is another example. The Supreme Court and the federal courts have been smart about this. They recognize that discriminators don't always wear the desire to discriminate on their sleeve, and they've developed tests, notably the Arlington Heights case, which was a fair housing case in the late 1970s, and identified factors to try to smoke out that use of illegal discrimination. Rational people can disagree on how to apply those factors in different cases or where they tend to point in different directions, but my bottom line is this. Just because a discriminator is hiding his or true intent doesn't mean that there's no discrimination going on. I was part of the team at Pacific Legal Foundation that litigated a case called Coalition for TJ versus Fairfax County School Board. This case involved a group of parents challenging a revamping to admissions at a prominent specialty high school that engages in specialty math and science education for gifted kids. In the fall of 2020, the Fairfax County School Board changed its admissions criteria because it wanted more students of some racial groups and fewer students from others, notably Asian Americans. It was pretty explicit in its background discussions, in its board meetings, in private discussions, in emails and text messages, which we later uncovered in discovery. They weren't doing this because they thought these changes would make the school better or more academically engaging or make its graduates more successful in science and technology careers or higher education. They wanted to do this because they felt that there were too many students of Asian American descent and too few of others. Because the precedent on K-12 education discrimination is somewhat less clear than was at the time somewhat less tolerant of the overt use of race than the Grutter case from 2003. They basically came up with a complicated Rube Goldberg formula that got them there. A certain number of students from each neighborhood school would be taken, and students who came from underrepresented schools would get preferential admission to TJ. Once again, although this was race neutral on its face, it was pretty clear that the goal was racial. Our team contended that it didn't matter that this criteria was facially race neutral because the end result for our clients was the same. This was a teenage kid who was getting shut out of the dream school that she could have attended a year or two before based on the old test, just because the board didn't want too many students from her racial group there. This, in our view, is just as racially discriminatory as a scheme that's more direct and wears its racially discriminatory colors on its face. We see some universities trying to do similar things in admissions following students for fair admissions. We see some similar things going on in training programs and other DEI programs, and I would contend that this is just as unlawful as using race itself is. Professor Edwards tried to draw a distinction between cases where the race neutral but actually race conscious criteria has an integrative versus a segregative purpose. I don't think that's a stable distinction. Many of these cases involve kids who are Asian American, kids from groups who have historically themselves been the victims of terrible discrimination. If you read through the discovery emails and texts, there's a lot of pretty crude use of racial stereotyping, crude use of anti-Asian comments. Maybe these people did have good intentions in their hearts when they started these programs, but reading through the way they talk about Asian American students, it hardly comes out that way. And I think that that's because when you discriminate on the basis of race, as Justice Thomas indicated, you wind up demeaning yourselves, you wind up demeaning us all by reducing these applicants, these kids, in their full humanity to these crude stereotypes based on race. Thank you so much. I look forward to your questions.
Okay, to respond to a couple great points that Allison has raised, I think first and foremost, I'm going to point out that Arlington Heights, as it stands now, does turn on this idea of invidious intent, on hostile intent. And so certainly I'm not suggesting that I am as aware of Coalition as TJ as she is. She has litigated the case. She knows it much better than I do. She knows the record. But based on her description here, it sounds like they had a classic Arlington Heights case where you had animus against Asian Americans. And so my perspective is in a case like that, you can show invidious intent, where you have the stereotyping, where you have the stigma against Asian Americans. We're trying to reduce Asian American representation rather than promote integration, promote diversity, because for whatever reason, we're not a fan of Asian Americans, maybe for some stereotypical reason. Again, I am not as familiar with Allison's case as she is, and I do not purport to claim that. And so there may have been other reasons why that argument wouldn't work. But under the Arlington Heights standard, if you show this animus towards a racial group, even if you were using race-neutral means to try to promote diversity, if you're doing so in a way intended to harm a group, I think you can still prevail. And now there's certainly an open question as to whether the Fourth Circuit applied the right standards in that case. My view is they did not, and we talked about that before we got up here and started chatting and discussing this issue. But again, I'm not going to go deeply into that just because it's not my case, and Allison is the expert here on that. I do want to address the point about the history here. Allison talked about the history of the South and Jim Crow using race-neutral laws to accomplish segregation, to accomplish racist goals. And I agree with her. We can't ignore the fact that the government is sometimes not stupid. It's not going to say, okay, I'm doing this because I want to discriminate. Sometimes it's going to say, oh, we're doing this, for race-neutral reasons, and then hiding behind that is some sort of animus or invidious intent towards, black people, towards Asian Americans, towards even white people. And in those situations, I think Arlington Heights accounts for them. In the situations like what was happening in the Old South, where we have race-neutral means being used for invidious purposes, we have law that accounts for it. And I support that law. I don't believe that we should have this entirely turn on whether it is race-conscious or race-neutral. I think instead it's a classification principle, at least under case law now, under SFFA. And so in the situations Alison described in history, I do believe it would be correct to say those were unconstitutional because the southern states were trying to accomplish invidious means. They were trying to discriminate against black people. They were trying to stop them from voting. They were trying to harm them as a group. On DEI programs and trainings, I agree. If they classify based off of race, if you're being told you're not allowed to take this program, you're not allowed to take part in it, you're not allowed to take this training because you are white, that is unconstitutional now, and very clearly so. I think where you deal with expressive DEI trainings that are not making those sorts of classifications, instead they're all comers, I think those are very much constitutional, and they are in fact constitutionally protected because they involve expression, they involve speech, and so they're protected by the First Amendment under most circumstances. There are some exceptions, and again, it's hard to get into those nuances here in the amount of time I have, as I've only got about 1 minute and 15 seconds. So in that vein, we are in agreement when DEI programs or DEI trainings tell certain people they can't participate based off of race, or when they create a hostile work or educational environment through severe and pervasive behavior. Maybe that's making the white people in the school do a privilege walk every day where they're yelled shame by the professors. That is very much illegal. But simply training people on ideas that some might find offensive, some people might not like, that is not illegal. That is protected by the First Amendment. You are allowed to speak to ideas that some people disagree with, that some people find offensive, that some people find unsavory. So if I want to stand up here and say I support affirmative action, and some people think that makes me a racist, well, I have that right. And certainly people who disagree with me have the right to voice their opinion too. So I think Alison and I are mostly in agreement with some small disagreements related to whether race-neutral programs can seek to accomplish benign race-conscious goals. So with that, I will stop it here, and I guess we're going to open up for Q&A.
All right. Let's give another big round of applause for our two speakers. So we have a Q&A microphone over here, so if anybody has questions, they can go ahead and start getting into the queue. But I'll go ahead and open it up with a couple of questions first. First, where do you all think that the Supreme Court litigation and just litigation in general on this topic is going to go in the next coming years?
I think we'll probably see another proxy discrimination case like Coalition for TJ. I think there will be cert petitions filed. Whether the court takes them, maybe that's not in the next couple years, but I could easily see that happening in the next 5 to 10 years.
Yeah, I think Alison's right on this. I see them taking up the sort of case she's talking about in the near future. It's hard to figure out what is on the justice's agenda at any given time, but certainly, as we were talking about before our debate, there seems to be 3 votes now that are for taking it up, and so they only really need to peel off one more person to put this before the court. What the court will do, I think, is an open question, and it's probably going to hinge on Justice Barrett or Justice Kavanaugh, which side of the issue they fall on. I am of the opinion, I don't think Chief Justice Roberts is yet ready to say that race-neutral programs aimed at, promoting diversity or promoting integration or reducing disparities are unconstitutional, but I'm not quite sure where Justice Barrett or Justice Kavanaugh lands on that issue.
I do think Chief Justice Roberts has a line about indirect discrimination doesn't allow you to do what you can't do directly in students for fair admissions that I think is a reference to this kind of program and a warning to schools, don't try to do too much of this. So I think Roberts could be a fourth vote for this kind of thing.
Certainly possible. I think that is true. That line is in there. I interpreted that line more as schools being kind of savvy in how they were implementing their admissions decisions and saying, tell me what your race is so we can try to get you in through this holistic approach without being explicit in our racial classifications. But he may have meant it more broadly than I interpreted it.
My next question is for Allison. I'm curious what your thoughts on Professor Edwards' interpretation of an originalist approach to the Harvard case, and what your thoughts on that are.
So I would refer anyone who's interested in this general question to Justice Thomas's concurring opinion in Students for Fair Admissions. He walks through the evidence of intent of the 14th Amendment at the founding, and he finds that it's largely consistent with the colorblind or universalist vision of equal protection. He admits that there are some early statutes that seem to go the other way, but a lot of them turn on some trait that's not actually race itself, but something that's correlated with it, such as freedmen's status, or given sort of the different historical circumstances the nation founded in, that these are laws that could be justified by modern strict scrutiny.
Feel free to respond to that, Professor Edwards, as well.
Sure. I think that Justice Thomas does offer an interesting take on the issue, and I admit that I am not an expert on 14th Amendment history. I dabble, nor would I classify myself as an originalist, although I do find originalism interesting, and I do try to understand certainly that approach to constitutional interpretation. I would direct people to an article in the Journal of American Constitutional History written by Kate Mazur and Gregory Downs that is designed to ameliorate the condition of people of color, the Reconstruction Republicans, and the question of affirmative action. There they show that there were multiple laws that were passed by the Reconstruction Congress that drafted and helped to enact and ratify the 14th Amendment that were indeed race-conscious laws, and that turned on, that were intended to benefit Black people especially, not just newly freed slaves, or not just newly freed enslaved persons, but also free Black people who were free before the Civil War and dealt with really repressive conditions in the South. And so they make a very compelling argument that this Reconstruction Congress intended something more akin to an anti-subordination principle, at least from my perspective. And really what that means is it was about an anti-caste principle that was about lifting groups up who had suffered discrimination in the past and repairing those things, ameliorating their condition.
My last question before we go over to the queue is, what are your guys' thoughts on scholarships and scholarships that are based on race, either private scholarships or public school scholarships?
If it's offered by a public institution that's bound by the protection clause, I think there's likely a legal problem. Same thing with a private institution, if assuming they're receiving federal money under Title VI. If it's being offered by an outside group, it's not clear to me that there's any civil rights law that prevents the private group from offering it, but an institution that's bound by the protection clause or Title VI may not be able to accept it.
Yeah, I think Allison's summary here is correct. I'm in agreement. I will say, though, that if these groups want to promote diversity, want to promote integration, they could offer a scholarship on like a race-neutral ground. Say, people who have suffered discrimination in their lifetime, who, they tell me about the discrimination you've suffered, and they could offer a scholarship based off of that. But I agree that they can't sort people by race.
I'm fine with that. In principle, the concern would be that if the criteria is chosen in a way that's meant to be racially exclusive or discriminatory, not merely something that has a disparate impact, that itself could constitute race discrimination.
Go ahead.
Hi, I'm Tommy. I'm a first year. Mind you, because I'm a first year, I am not as well versed on the constitutionality of some of this. I do have multiple questions, but I will just say the most legally pressing one first, because at least to hopefully not hog the mic in case other people want to speak. But first one in particular, I'm curious about the impact on private schools and if they're able to continue such practices, but also as well of I'm from Florida, and I know that we've done a number of things trying to combat it, especially when it comes to both public and private institutions by cutting fundings or to certain programs or things like that to help combat DEI programs. And I'm curious about the constitutionality and legality about both of those as well. I'll save my other questions for after.
So on the private schools issue, the Students for Fair Admissions decision applies to private schools that take federal money, which is virtually all private universities in the United States, so they're still significantly restricted. I'm not sure I understood the second half of your question about what you were asking about DEI in specific states, or
Some states are withholding funding from private universities and as well as public ones in order to prevent DEI or in particular, kind of like what Professor Edwards was saying, of instituting programs without directly stating race, but beating around the bush to kind of keep it in practice. And I'm curious about the legality behind that.
so if the university is using criteria that has a racial goal, even if it's race neutral, then there is a legal problem, and I would be concerned about that. There might, in some cases, be state laws that are more restrictive than the federal constitutional rule or Title VI, and if the state's doing that to comply with those, then I think that's appropriate. Um, I'm sorry. Was there another piece to what you were asking about in terms of expressive activity, or?
That's about it for that question, at least.
Yeah, and I can jump in maybe a little bit and add
Okay.
a little flavor here. I worked in Florida before starting here at West Virginia University College of Law, and so I think I know the law you're referring to, at least one of them. SB 266 was one of those laws that was aimed at defunding DEI at public universities. And my view of that law is that it was unconstitutional, and the reason why is that it reached expressive activities by faculty and it reached expressive activities by student organizations. And so before I left the ACLU of Florida, I helped put together a lawsuit challenging it. One of our plaintiffs was a professor at the University of Florida who was denied funding to attend an academic conference, even though funding was guaranteed to her per her employment agreement, because she was going to be presenting on a diversity-related issue. In fact, she was presenting a piece that criticized anti-DEI laws in a historical context. And so from my vantage point, that did violate the First Amendment because it was punishing her on the basis of her viewpoint and stripping her of funding on the basis of her viewpoint. And one of the legal doctrines I could not get into today due to time constraints is unconstitutional conditions, what you can't do indirectly. You can't do indirectly what you cannot do directly. And so you can't tell somebody you're not going to fund them if they speak on an issue, if you can't tell that person you're not allowed to speak on this issue directly. And so what Florida was doing there was trying to accomplish by indirect means what it could not accomplish by direct means.
No one else? Do you have another question? Because I'm not going to hog the mic if other people have questions.
Oh, sure.
There we go. So the question I have kind of starts with a statement. I think that it's hard to address DEI in just this small portion of time. And I think that maybe in creating this debate that maybe that wasn't necessarily thought of because I may have missed this, but it sounds like we didn't even address what DEI is. It seems like, Alison, your idea of DEI was just race. And the reality is that's not what DEI is. So my question is, when you are considering why DEI should be removed, is it exclusively because of racial bias? Because if that's the case, we can remove racial bias without removing DEI.
I agree that the term is really broad and that a lot of debates and discussions can kind of get bogged down in definitional issues. I think that when people criticize DEI or even when people praise it, a lot of the focus is on racial preference. That is an important part of DEI as it exists in the real world, and that's where I think the legal issues are sharpest, so that's where I'd focus this presentation. I agree that an issue as big as complex as this, it's difficult to cover in an hour. I would absolutely encourage you to visit my employer's website, pacificlegal.org, to learn more about our cases, see explainers on this concept, op-eds by my colleagues and me, and you can absolutely learn more about what you think. There's a whole wonderful world of information out there.
No, I agree. I mean, I think I tried to give a very broad overview of what could constitute a DEI program, but it is very hard to define the term, and it is certainly broader than race. It can encompass sexual orientation, it can encompass veteran status, it can encompass disability, and a number of other statuses. And so, I don't want to give the impression that DEI is just focused on race. Rather, because our discussion was focused on the Equal Protection Clause, I did keep my focus pretty narrow given the time constraints. But that is a very fair point.
So follow-up question then, what is DEI and what is the issue that you have with it then? Because if you don't have an issue with DEI as a whole, I think that that should be said. It seems like maybe the part that you thought was most significant was the racial aspect of it. And I think that Professor Edwards agreed with that, that that was, maybe something we should look at. But if that's the issue, then that's the issue. DEI isn't the issue then. DEI doesn't need to die if racial issues are the issue.
So I think that a lot of people who work in offices that have the DEI title or consider themselves DEI trainers, they see racial preferences, racial favoritism as integral to what it does. And so I do think it's important to criticize that because that kind of racial favoritism is largely forbidden by the Constitution and by the civil rights statutes and is therefore worth criticizing. I agree that there are some DEI programs that do other things that are either neutral or praiseworthy.
So just want to clarify that. Your answer is then DEI is not the issue. It's the way that sometimes it's implemented.
That's fair.
Thank you.
Okay, my other two questions, in a bit less in the legal side, but still curious about it, especially for the point that was made of when it came to diversity of thought or thing, especially when it comes to political identity. How come we don't really see much of that, at least nowadays, especially where you don't really hear cases of people who are like syndicalists, monarchists, plutocrats getting any benefit for if one of the main arguments for it is diversity of thought, but also as well when it comes to benefit of the disenfranchised, and at least if I'm understanding correctly from what you both were saying, that we're kind of moving more towards like the example that Professor Edwards gave about Texas, and that of especially where if especially are we really seeing much of a move more towards that generally? Like an example of when it comes to economic class or things like that, both it is a difference in outcome that affected their lifestyle, like often leading to lesser grades. Yes, there's often a correlation between certain groups, but are we seeing much of a move into that regard to really truly benefit disenfranchised and not just people who just happen to be part of one group or another?
I don't really have any objection, at least legally, to using universities or other bodies pursuing diversity based on political ideology or thought. I think the problem is that a lot of universities claim to be pursuing diversity writ large in their admissions policies, but actually narrowly focus on race and a few other preferred categories. And so the diversity rationale that Justice O'Connor thought many universities were following, they weren't and aren't actually following, and that's a problem.
So, my perspective is on SFFA. If there is a good thing that could come out of this decision, which I disagree with the outcome, I disagree with the rationale in SFFA, but if there is a good thing that can come out of it, I think it's universities focusing more on other forms of diversity, like socioeconomic diversity. I think there were some studies done of like the top universities, like Harvard, like Yale, and they weren't very socioeconomically diverse. And I think that is a problem because I do think we should appreciate diversity across many different areas. And so if that is something that results from SFFA, if universities say, we do want diversity, And we think the best race-neutral way to promote diversity is by focusing on other forms of diversity, geographic diversity, socioeconomic diversity, diversity of thought. I think that is potentially a benefit that comes out of it, obviously with some costs.
Also, to further clarify with diversity of thought, I was more of wondering why are we not seeing more of that, especially when it's one of the main points for arguing DEI in general.
I think because unfortunately many universities just don't value it that much, and that's unfortunate. I hope others step into the fray and start to pursue it more earnestly.
Thank you.
Mine's going to be, I'm going to try to make it concise, sorry. So in regard to DEI, I guess the proposal for it to go away, what's the idea to replace it with? What program could be used to facilitate that and to improve it?
I don't think there has to be a single answer across institutions. For example, religious schools have their own systems of trying to make sure people feel integrated, make sure people feel supported and welcome, and those are going to look different from what they look like at secular schools. Secular schools will also have their own distinctive traditions and ways of welcoming and integrating people in. I don't think there has to be a one-size-fits-all answer. I think what's important is not to classify people arbitrarily on the basis of race.
Good answer. And then broadening on that, since we still continue to see that even to this day, not everyone has equal rights. We see the overturning of Roe versus Wade before the fact that that was even codified. Not everybody even has equal rights at this moment. It tried to happen, back in the 70s, but then, we have other things like the Community Reinvestment Act of 1977 that happened. And then precipitating all of that, we go back to 1848, whenever James K. Polk, whenever he had Congress, they didn't ratify Article 10 of the Treaty of Guadalupe Hidalgo that allowed people to keep their ancestral homes in California, Arizona, Utah, Colorado, Texas. All those things were taken. And then precipitating that even further, we go back to 1776. Next year will be 250 years that we've been a country, but some of these people who had homes in California, their ancestral homes, they had them for 500 years before Manifest Destiny happened. So what's your idea of replacing DEI with something that's going to be comparable to evening the playing field?
So there are lots of different public policies that aim to increase opportunity and even the playing field. At my public interest law firm, Pacific Legal Foundation, we have chosen to focus a few. In our equal opportunity practice group, we sue state and local governments that put up policies that are barriers to opportunity. For example, we have one client who is working on challenging the certificate of need laws in Louisiana. She wants to open a small business that provides respite care to special needs children. She's blocked by a certificate of need law that says the government basically gets veto power over whether she's able to open up her business. She thinks that's a violation of the long neglected privileges or immunities clause, a whole other 14th Amendment lecture than what I can give today. But I think that's the kind of thing that we're working on doing. We have a similar property rights group that's trying to work on ways to make it easier to build, make it easier for Americans to own a home, build up wealth and savings plans. I don't claim that we're perfect. We're working on a few important causes, but I think that they are real solutions that help level up and build opportunity out for everybody.
So that's a tough question. I think we've struggled with that for many decades, how to remedy historic injustices and historic discrimination. I think that the more our law goes in the direction of pure, unadulterated color blindness, I think it gets harder to pass public policy to do that. And that's why my view of the 14th Amendment is one of anti-subordination, one where you should be able to redress historic wrongs done, redress wrongs that continue to today. I admit, as Alison pointed out earlier, that isn't consistent with the precedent. It's not consistent with the stare decisis that existed before SFFA. I would side with the dissenters and Bakke with Justice Marshall. And so that is the direction I would go. But certainly it's difficult no matter what direction you go.
Tank, did you have a question? Thank you all for coming and showing up today. If there aren't any more questions, let's give one more big round of applause for our speakers. Really appreciate everyone coming out tonight.
Good panel, thank you.
That's great. I agree with y'all that privileges. How we implement that, I don't know.